1966ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်935 B KADASARIA Appellant vs ဦးကြည် Respondent ဤစီရင်ထုံး Audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Miscellaneous Appeal before ဦးသက်ဖေ Judge B KADASARIA Appellant vs ဦးကြည် Respondent Execution of Consent Decree Money Lenders Act 1945 carrying on money lending business after the enforcement of the Act, but ceasing after a certain period, whether a money lender within the meaning of the Act, carrying on the business of money lending after a period of money lending certificate, whether to be regarded as a money lender as defined in Section 2, Section 9 of the Money Lenders Act, prohibiting court from passing any order on the application of a money lender for execution of a decree, registration of money lender to be enforced, whether relief can be granted when license expires before making any order. Hell, a person who carries on money lending business after the enforcement of the Act but ceases after a certain period will remain a money lender within the meaning of the Act. The appellant has admittedly carried on the business of money lending till April 18, 1965, when his money lending certificate expired. He must still be regarded as a money lender as defined in Section 2 of the Money Lending Act and is therefore governed by the provisions of the Act. Section 9 of the Money Lenders Act clearly prohibits a court from passing any order on the application of a money lender for execution of a decree until and unless the money lender is registered under the Money Lenders Act and the registration is also enforced. In other words, the registration must be enforced at the time when the court contemplates to pass an order on the application of the money lender, although the registration may be enforced at the time when the execution application is made. No relief can be granted when the license expires before any order is actually made. Tan on for the appellant, Nhin So for the respondent, Utapi, Judge. In the Rangoon City Civil Court, appellant obtained a consent decree for Jet 20,000 against the respondent and the execution of the decree was, by mutual agreement, still for 6 months. Before the expiry of the period of 6 months, the respondent applied and obtained an order to pay the decreed amount by monthly installment of Jet 900 with effect from 17 May 1965. But he defaulted in payment after depositing 2 installments with the result that the appellant made an application on 23 July 1965 for permission to execute the balance of the decreed amount. The application was, however, resisted by the respondent on the ground that the appellant being a money lender could not execute the decree under Section 9 Money Lenders Act 1945, inasmuch as his money lending certificate had already expired on 18 April 1965. The contention of the respondent was accepted by the Learned Chief Judge of the Rangoon City Civil Court, who had seasoned of the case, and the execution application was accordingly dismissed. It is against the order of dismissal of the execution application the present appeal has been brought. It has been argued on behalf of the appellant that the provisions of the Money Lenders Act 1945 do not apply to the instant case, inasmuch as the appellant, who is merely winding up his money lending business after the expiry of his money lending certificate on 18 April 1965, ceases to be a money lender within the meaning of the Act. The definition of money lender has been given in subsection C of Section 2 of the Act, which reads, money lender means a person who carries on the business of advancing loans as defined in this Act and shall include his legal representative and successor in interest, whether by inheritance, assignment, or otherwise, provided that nothing in this definition shall apply to a person who is the legal representative or is by inheritance the successor in interest of a deceased money lender, together with all his rights and liabilities, if such person only winds up the estate of such money lender and does not advance any fresh loans, or b. a person who from the date on which this Act comes into force merely winds up his money lending business and does not advance any fresh loans. We are directly concerned with Proviso B, according to which a person who does not advance fresh loans, but merely winds up his money lending business on the 2nd November 1945, the day on which the Money Lenders Act 1945 came into force, will not come within the definition of money lender. It therefore follows that a person who carries on money lending business after the enforcement of the Act, but ceases after a certain period, will remain a money lender within the meaning of the Act. Since the appellant in the present case has admittedly carried on the business of money lending till 18 April 1965, when his money lending certificate last expired, he must still be regarded as a money lender as defined in Section 2C and is therefore governed by the provisions of the Act. The next point that has been canvassed on behalf of the appellant is that since he has initiated the execution of the decree before the money lending license expires, he should be allowed to continue the execution inasmuch as the act of the executing court in closing the execution proceedings when it ordered payment of the decreed amount by installments, which has since been flouted by the respondent, should not be allowed to prejudice his right. In this connection, we will have to look to Section 9 of the Money Lenders Act, the relevant portion of which provides, notwithstanding anything contained in any other law for the time being in force, no court shall pass an order on an application by a moneylender for the execution of a decree relating to a loan or to any security in respect of a loan, unless the moneylender is registered under this Act and the registration is in force. The above section clearly prohibits a court from passing any order on the application of a moneylender for execution of a decree until and unless the moneylender is registered under the Moneylenders Act and the registration is also in force. In other words, the registration must be in force at the time when the court contemplates to pass an order on the application of the moneylender. Although the registration may be in force at the time when the execution application is made, no relief can be granted when the license expires before any order is actually made. In the present case, even assuming that the appellant has instituted his execution application before the expiry of his money lending license, which in fact is not, the court cannot possibly grant him any relief inasmuch as his license has expired before any order is contemplated by the court. It has been said that the moneylenders will face much hardship if Section 9 Moneylenders Act is not interpreted more liberally. It must at once be pointed out that the Moneylenders Act has been enacted for the benefit of the working people as a whole, and it is but natural that some hardship may occasion to the moneylenders who found only a minute fraction of the working people. A court of law whose duty is to enforce the law as it stands cannot listen to any argument of hardship, lest it might result in the introduction of bad law and erroneous interpretation of statute. In the result, the appeal fails and is accordingly dismissed. In the circumstances of the case, there will be no order as to cause.